I bet you've been hearing a lot about this recently, especially because just this week, Australia officially implemented their right to disconnect laws, and it's fully in effect. But here's the thing, what about New Zealand? There's been a lot of conversation, but my hot take actually questions if it's really all that different from what we already have. Stick around and let's get into some spicy discussions around contacting your employees after hours. Hi everyone, welcome back to Law Lenz. My name is Sanam and thank you so much for tuning in today. If you've been hearing about the right to disconnect, then you must be wanting to stop this episode right now because you are done and dusted hearing about it. But I am a bit concerned because whenever I see this conversation popping up, and I've been following it, being in the Australian space as well, and one of the things that I realized was that the conversation has actually been quite superficial when it comes to New Zealand. I even heard the Labour Party workplace minister say that we need something in place in New Zealand, but there are already protections in place for employees anyways. And a lot of times, even in Australia, the legislation and what's been put in place is actually quite misconstrued. So I thought we can talk about what Australia has and get into actually what New Zealand has as well for a more in-depth discussion. But before we get into it, you know what time it is. It's time for Laughs with Law Lenz, where I give you a dry joke in these episodes. My boss told me to have a good day, so I didn't go into work. I thought this would be very fitting for the right to disconnect, because what you want to do after work when you're just not wanting to respond to those emails is just disconnect and maybe shut off for the day. If you like these episodes and if you are liking Law Lenz, then don't forget to subscribe and share with someone who needs to hear this information. And if you want more insights on how to navigate the world when it comes to employment law, then head over to my LinkedIn page or even check out all of the podcast episodes in the library. Now, you may be thinking, what is the right to disconnect? Right? What is it exactly? Essentially, the legislation is aimed at addressing one of the biggest issues that we're seeing in the workplace. When the COVID pandemic hit, we knew that a lot of people had work creeping into their personal time. I work fully remote in my day job, and look, remote working is not for everyone. We always talk about remote working and talk about flexibility and how amazing it is, and you can do what you want and go on that lunch or go to that appointment. But the reality is that it's not that easy. A lot of times you can have your job basically creep into your personal life. All of a sudden, you're checking your Slack messages, or maybe on Teams, you see something pop up, maybe an email come through, and all of a sudden you're at a dinner and you're checking your phone. So what happens? Because we saw this during the pandemic where the lines got really blurred. And so in Australia, we saw that the right to disconnect is that employees can refuse contact outside of their working hours as long as that refusal is reasonable. If their refusal is unreasonable, then that is a problem. So it's no longer about feeling obligated to answer that email or to take that call because you're off the clock, right? You're not at work. But here's where things get a little bit more interesting. What counts as reasonable or unreasonable refusal is really important. And this is a question when we did the webinar for Australia, it came up time and time again. And what factors really need to be looked at here is why the contact is being made, how disruptive the contact is to the employee's personal time, whether the employee is being compensated for being available for that time, whether their role in the company is senior enough where they need to be contacted outside of hours. You know, if you're a CFO and you're going through an audit, maybe that has higher ranking over somebody that might be working in a support role, for example. And if there's any personal circumstances that you have which might hinder you from being able to respond after hours, if you have caregiving responsibilities or family members to take care of. So there are a lot of factors here that need to be considered. Essentially, if refusing is unreasonable, then that's when it's an issue and the employer can say to the employee that this is ridiculous. But if the employee is in a situation where they reasonably can refuse for those reasons, then that's when the employee is in a better off position. So let's have a look at New Zealand and let's really compare the differences. Yes, we do not have a right to disconnect law, but that doesn't mean that the employees of New Zealand are left unprotected, because for many years we've had cases about excessive hours come up. We've had a lot of issues where employees will not be remunerated, especially salaried workers, will not be remunerated for those additional hours. We've all heard reasonable additional hours, right? I'm doing air quotes right now because we know what that means. So our laws already, like the Employment Relations Act, for example, place restrictions on employers demanding or asking employees to work beyond their agreed hours. What the Act actually says, for example, and what we saw in, I think it was around 2016, was that 0-hour contracts were banned. So employers couldn't just require an employee to be on call. They needed to explicitly state that in the employment agreement, and the employee needed to be paid for that. Kind of like the right to disconnect, where I mentioned a bit earlier that if the employee is being compensated for being available outside of their regular hours, then it is very reasonable for them to respond to their employer. Same thing in New Zealand. We just have a bit of different terminology, and it's not all neatly packed under one section of the legislation. But we actually do see a lot of times that employees will raise claims. They can even raise a disadvantage claim for unjustified disadvantage if something comes up there in relation to them being given these excessive hours and not remunerated. And then you also have this side of it as well, which is that they're doing all these additional hours, but they're not necessarily on call, but they're being told that they need to be made available. And not only that, we also have privacy legislation as well that's in place. What we've seen with privacy legislation is that you can use personal information, such as an employee's contact number or contact details, for a particular reason and for a particular purpose. It can't be in contravention of that purpose. It should be in alignment with what it needs to be used for. So under the health and safety legislation currently in New Zealand, employers have a responsibility to monitor employees' workloads. What they need to do is make sure that they are not providing work that is in excess to the point where it's at risk of causing the employee to be excessively stressed or overworked. If an employee at any point raises any concerns around workplace stress or any issues around being excessively piled on with work, and that could be even related to after hours contact as well, then an employer will need to take this seriously, and it is part of their health and safety obligations that they work with the employee as well as their good faith obligations to respond in a timely manner and be communicative. The reality is that not every employee wants to disconnect, and I know this is a hot take. Not every employee wants to fully disconnect. There are a lot of employees that are in higher roles that are wearing multiple hats within a company where they are happy to do the work. But I have read a few things here and there, conflicting arguments around this. And one of the arguments that came up by an advocate was around the fact that people are actually addicted to work, and they have this fear that they're going to miss out on the work if they're not engaged with their workplace 24/7. Now, if you're nodding your head, because I'm nodding mine too, we've been there, right? We've been there to the point where, recently I went on a couple of weeks leave. If you've been following the podcast, you know that I was in Fiji, and I was so pedantic for the month before, letting everyone know, organizing everything, doing handovers, doing this and doing that. And I was thinking, this is a lot for 2 weeks. So that's why it's really important, I feel, for employers and employees to really set up very clear boundaries. And that can be done within the parameters of the law that we have at the moment. We don't need a right to disconnect law. For every employer out there that feels like their employees might be overworked, know that you have an obligation. And we are seeing a lot of burnout cases coming out paying high amounts of compensation. So it's really important for employers to catch the signs early and to make sure that they have created these parameters in the workplace. Now, if you feel like as a business, you have a lot of employees going home, working, a lot of employees feel overwhelmed, feel stressed out, you can put things in place to make it a better workplace so that not only are your employees feeling a lot better and they have better well-being, but it'll actually make them more efficient. I know it's crazy to think that working 24/7 isn't the efficient way, but there are other ways to do it. And my practical solutions here would be definitely have a look at finding the sweet spot for your business between flexibility and disconnecting, because it's not the same for everyone. And that's why I feel like a blanket piece of legislation complicates things. Firstly, I would recommend putting a policy in place. The right to disconnect policy in Australia can honestly be ripped and taken. Obviously, it won't be relying on legislation, but it can take the health and safety angle. It can take the angle of we want people to be able to be at home enjoy their personal lives and not have to worry about work. Set the expectation that if you're getting an email, that it doesn't need to be responded to straight away. It can be responded to later. That's absolutely fine. A lot of times we have this expectation on ourselves that we need to respond, but it's really important for the company to make it very clear that this expectation is not there and it's not a requirement. So that's the first thing. Have a very clear policy in place. Design it how you want. Base it off of what works for your business, what's practical. But then also, little things. Think about giving your senior employees who need to stay connected a work phone. You know, when I got into private practice, I thought, wow, I am just a budding lawyer. I am living the dream. Let me use my personal mobile number as the one for clients to contact me. Such a bad decision. So bad. The worst I've ever made in my life. Because I tell you what, it's not fun getting a call at 8 a.m. on a Sunday from a client, ignoring their call because you've now memorized the last few digits of their number, and constantly getting called after that for the next half an hour or so. It's not ideal, right? Especially when you're trying to sleep in on a Sunday. So, highly recommend something as simple as giving them a work phone where they can actually disconnect and they can separate their personal and professional communications. And I know people don't like carrying around two phones. And I used to hate it. And that's why I thought, I'll just make it all one. Regret. Instant regrets about that. Now, also, don't underestimate simple things like text solutions, very simple text solutions. For example, scheduling your emails, doing a schedule send when you need to send them so that they can look at them tomorrow. It's such a great thing. You won't disrupt their evenings and their personal time with these midnight messages, because when you're running a business and you're a director of a company and you're a small business, you are thinking about things all the time. I remember when I was an advisor, I would take the after hours phone. And what would happen there is that people would call maybe at 12 a.m. or 1 a.m. And the questions that they would ask would be things like, how do I calculate annual leave? Because these directors, they are working in their business all day. And then now all of a sudden, this is their only free time. And this is when they really want to learn about parts of employment law. So think about the impact that will have on your team. And even if you operate 24/7, they don't need to, right? And for those employees that are out there, or those managers or those leaders, remember, the more senior you are, the more weight your late night messages carry. So what I'm saying here is be mindful of the impact on your team's well-being. When sending out of hours communications and messages, make sure that you're setting those boundaries and making it very clear what your expectations are. Something as simple as throwing in a sentence in there that says, please don't look at this right now. It's for tomorrow morning, but just an FYI. That's all you've got to do. So as you can see, New Zealand, yes, we don't officially have a right to disconnect law like Australia, but that doesn't mean we're lagging significantly behind. I'm so tired of hearing that rhetoric. Instead, our employment laws already offer a strong framework. They already offer a path for employees to raise a grievance. And they already offer the ability for the employee to go down that path. I've dealt with those personal grievances where employees have said that they have worked more hours than what they were contracted to, or more hours than what they were paid. But, it'll be interesting to see if this is something that the coalition government is going to be looking at. I feel like it'll be kind of counterintuitive to what their positioning is on these things usually. They're obviously a little bit more employer-centric in their approach. So I can't see this being introduced in New Zealand anytime soon. But never say never, because it could come out. Well, thank you so much, everyone, for tuning in today. If you enjoyed this episode, then like I said, don't forget to subscribe and make sure that you share it with your colleagues, your friends, people that need to hear this information, because I'm trying to get the word out there so that everyone's compliant and feeling good about the workplace. And if you want more insights, then definitely jump over onto LinkedIn or check out some more episodes. But until next time, thank you so much, everyone. I hope you have a lovely day, night, evening, morning, whatever it may be. And I'll catch you in the next one, everyone.